Greathouse on your docket.
Mr. Greathouse, come up.
Judge, you told him not to drive. The allegation is that he was...
This case isn't what it seems. And it starts with a contradiction that could flip the whole thing. The defendant accused of driving on a suspended license. But here's the kicker. That suspension might never have existed. The defense comes out swinging, dropping a dismissed ALR order like it's a royal flush. So, why did the judge tell him not to drive? Was it a legal misunderstanding or something deeper? And no, buckle up because the courtroom heat is just getting started. What would you do if pre-trial said go, but the judge said no?
Driving. First of all, Judge, I want to speak on when you told him not to drive, it was because the state told you that he had an ALR suspension. What I've got for you, Judge, I couldn't access it at the time because I don't have access to our closed files. This is an ALR dismissal order.
No, okay.
There was never a suspension on his license at all. He's been good to drive.
But he was also drinking. The concern was that he was drinking.
But Judge, you told him before you left that that you were doing this because there was already a suspension on his license that he couldn't drive. I never got the impression that you were taking that action because he was drinking.
He was drinking allegedly, and
Yes.
the license was suspended.
Yes.
Can you run his license, please, state?
There should be a witness here.
Did it just become eligible, or when was it eligible? You know what? Let's do this. I have a line of people. I've got arraignments. Let me put this off a little bit because this is going to take a
I
lot
had
more
to go
time.
to the doctor's office. I sent you an email on Friday when you said this. I'm supposed to be at the doctor. I took today off, but I never got a response then when I asked to move this to tomorrow. So I've got to get it done. I've got to be at the doctor.
So we can do it tomorrow. You want to tomorrow?
I'm already
Let me
here,
look at
Judge.
what,
I'm already here.
Your Honor, it looks like it was lifted on 4/2/2025.
said, what day was it lifted?
4/2/2025, from what I can see on the license. It's the ICC.
And what are the days that he's alleged to be driving?
The second, Judge, let me double check.
And does he have an interlock as well?
Yes, Judge, he has an interlock. He was alleged to be driving on the second and the third.
Furthermore, Judge, the bond conditions that you signed on the 28th, nothing on those bond conditions says he can't drive. And my client tells me that when he went to pretrial services, he was told repeatedly, because he asked repeatedly, if he could drive. And so I think pretrial has the apparent authority to tell him what the bond conditions are, especially for somebody, a layperson who, when he goes there, he doesn't.
There is a no driving affidavit on file as of March 28th, where I ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in violation of a court order. You come here, you ask for permission, and then we give you permission. You don't just go do something.
Okay, pause. That wasn't just courtroom drama. That was a judicial mic drop. I don't give a damn who Jesus tells him. That line came after a heated back and forth about whether pretrial services had the authority to override a court order. Spoiler, they don't. Under Texas law, a court order is binding unless formally overturned, regardless of what anyone else says. This moment, it's the turning point where misunderstanding meets legal reality. The defense tried to argue implied permission, but the judge's patience gone. Would you risk driving if pretrial told you to, or play it safe and wait for the court's green light?
Forgiveness after the fact.
It's told by pretrial services.
I don't give a damn who Jesus tells him.
Judge, you don't.
Doesn't matter. A court order is a damn court order. Just because pretrial services just tells you something doesn't. Really? Is that what it's now come to?
This was all premised on wrong information that he couldn't drive. He can drive. There's nothing wrong with his license. There was no ALR suspension ever. The state told you that. That's why you
Was a suspension,
It was
and
not
it
an
was
ALR suspension,
lifted
Judge.
on.
4/2, Your Honor.
There was no ALR suspension. I got the case dismissed. It's not possible. I mean, would you like to see the email or the dismissal ordinance from jurisdiction? Because it's right here.
Dude, I'm just looking at the records.
That's fine. I'm showing
We
you.
were mentioned it was begin date 1/3/2025, lift date 4/2/2025.
It's not possible because it was dismissed with prejudice.
12/6/2024.
End
Herrera,
date 6/3/2025, and the lift date comes in at.
And then if that,
I'm not saying you're wrong, what I'm saying is, based on what I can see, is what, all I can see.
if there's a dismissal
So in the end, the defendant walks, but just barely. Turns out he was legally allowed to drive, but only by the skin of a paper trail. One more missing document, and he'd have been in jail. This case, a wild ride through legal gray zones, courtroom tension, and a judge ready to throw down. If your jaw's on the floor, smash that like button, drop your verdict in the comments, and subscribe for courtroom drama that's stranger than fiction.
suspension is contrary to law, and it's void.
I'm going on what DPS says. I don't have access to what you have. I don't know. All I know is please, you don't need to put your computer. All I'm saying is that regardless, Mr. Johnson, our court order is a court order.
I understand.
You don't just do something willy-nilly because you think that you're in the right because of this. No. We have court orders for a reason. If you ever do this again, I will have a contempt hearing. I'm warning you now. And the next time you do something contrary to anything, I'm going to throw you in jail so fast, your head's be spinning as fast as a wheel. Now, you have a CDL, am I right?
It's a license check.
I'm not going to put you in jail now, but I want to make sure that you're not drinking. So does he have a scram on right now?
yes, Judge.
Okay. Everything's operational?
Yes, Judge.
Don't do it again. The only reason I'm not taking you into custody now is because your license was valid on the 2nd and 3rd. Otherwise, you would be staying with me. Don't violate a court order. We tell you what to do, not pretrial, not anyone else. Do you understand?
Sir.
All right.
Good luck, sir. Thank you, Judge. And this is where everything unravels. The defense presents hard evidence, a dismissal order proving the alleged suspension never legally existed. But here's the twist. The judge only sees what DPS shows on their system. That means the defendant was held to a court order based on outdated or incorrect info. So now ask yourself, if the order was built on a legal ghost, does it still hold weight? This is where law and logistics collide, and one false record nearly landed someone in jail. Makes you wonder how many court orders out there are based on bad data.
Thank you, Judge.
Good luck.